ಯಾರ ಹೆಸರಿನಲ್ಲಿ ಈ ಸಂಸ್ಥೆ ದಿವಂಗತ ಡಾಕ್ಟರ್ ಡಿ.ವಿ. ಗುಂಡಪ್ಪ ಅವರಿಂದ ಈಗ್ಗೆ 66 ವರ್ಷ ಹಿಂದೆ ಸ್ಥಾಪಿತವಾಗಿ ನಡ್ಕೊಂಡು ಬರ್ತಾ ಇದೆಯೋ, ಆ ಗೋಪಾಲಕೃಷ್ಣ ಗೋಖಲೆ ಅವರ 145ನೇ ಜನ್ಮದಿನ ಇವತ್ತು. ಗೋಖಲೆ ಅವರ ಜನನ 1866, ಅವರು ನಿಧನರಾದದ್ದು 1915. ಕಾಂಗ್ರೆಸ್ಸಿನ ಮೊದಲ ಪೀಳಿಗೆಯ ಅಗ್ರಪಂಕ್ತಿಯಲ್ಲಿದ್ದವರು ಗೋಖಲೆ. ಮಹಾದೇವ ಗೋವಿಂದ ರಾನಡೆ ಅವರ ಶಿಷ್ಯರಾಗಿ ಅವರ ಉದಾರ ಚಿಂತನ ರೀತಿಯನ್ನು ಮುಂದುವರೆಸಿದವರು. ಭಾರತೀಯರು, ಆಂಗ್ಲರು ಇಬ್ಬರ ಗೌರವಾದರಗಳಿಗೂ ಪಾತ್ರರಾಗಿದ್ದವರು ಗೋಖಲೆ. ಪುಣೆಯ ಡೆಕ್ಕನ್ ಎಜುಕೇಷನ್ ಸೊಸೈಟಿ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಯಲ್ಲಿ ಬೋಧಕರಾಗಿದ್ದರು. ಅರ್ಥಶಾಸ್ತ್ರ ತಜ್ಞತೆ, ಸಾರ್ವಜನಿಕ ಹಿತದ ಬಗ್ಗೆ ಅವರಿಗಿದ್ದ ಗಾಢ ಕಳಕಳಿಯಿಂದಾಗಿ ಮುಂಬೈ ಲೆಜಿಸ್ಲೇಟಿವ್ ಕೌನ್ಸಿಲ್ ಸದಸ್ಯರಾಗಿ ಉತ್ತರೋತ್ತರ 1902ರಿಂದ ಆಗಿನ ಸಂಸತ್ತು ಅಂದರೆ ಇಂಪೀರಿಯಲ್ ಲೆಜಿಸ್ಲೇಟಿವ್ ಕೌನ್ಸಿಲ್ ಅದರ ಸದಸ್ಯರಾಗಿ ನಿಯುಕ್ತರಾಗಿ ತಮ್ಮ ಜನಪರ ಧೋರಣೆಯಿಂದ ತುಂಬ ಗಣ್ಯತೆ ಪಡೆದಿದ್ದರು. ಕೆಲಕಾಲ ಅಖಿಲ ಭಾರತ ಕಾಂಗ್ರೆಸ್ಸಿನ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಯಾಗಿದ್ದರು. 1905ರಲ್ಲಿ ವಾರಣಾಸಿಯಲ್ಲಿ ನಡೆದ ಅಖಿಲ ಭಾರತ ಕಾಂಗ್ರೆಸ್ ಅಧಿವೇಶನದ ಅಧ್ಯಕ್ಷರಾಗಿದ್ದರು. ಸಂವಿಧಾನಿಕ ಮಾರ್ಗಗಳಲ್ಲಿ ದೇಶ ಸೇವೆ ಮಾಡುವ ಪೂರ್ಣಾವಧಿ ಕಾರ್ಯಕರ್ತರ ನಿರ್ಮಾಣಕ್ಕೋಸ್ಕರ 1905ರಲ್ಲಿ ಸರ್ವೆಂಟ್ಸ್ ಆಫ್ ಇಂಡಿಯಾ ಸೊಸೈಟಿ ಆ ಸಂಸ್ಥೆಯನ್ನು ಪುಣೆಯಲ್ಲಿ ಸ್ಥಾಪನೆ ಮಾಡಿದರು. ಗೋಖಲೆ ಅವರನ್ನು ಗಾಂಧೀಜಿ ಮೈ ಪೊಲಿಟಿಕಲ್ ಗುರು ಅಂತ ಅವರು ಪರಿಗಣನೆ ಮಾಡಿದರು. ಗಾಂಧಿಯವರು ಗೋಖಲೆ ಅವರನ್ನು ಮೊದಲು ಭೇಟಿಯಾಗಿದ್ದು 1896ರಲ್ಲಿ. ಆ ಹಂತದಲ್ಲಿ ಗಾಂಧಿಯವರಿಗೆ ಭಾರತಕ್ಕೆ ಹಿಂದಿರುಗಿ ಇಲ್ಲಿಯೇ ನೆಲೆಸುವ ಅಭಿಪ್ರಾಯ ಕೂಡ ಇರಲಿಲ್ಲ. ಆಫ್ರಿಕಾದಲ್ಲೇ ಸ್ಥಿರವಾಗಿ ಉಳಿಯಬೇಕು ಅಂತಲೇ ಗಾಂಧಿಯವರು ಆ ಹಂತದಲ್ಲಿ ಅಂದುಕೊಂಡಿದ್ದರು. ಆ ಹಂತದಿಂದ ಗಾಂಧಿಯವರ ಚಿಂತನೆಯನ್ನು, ಕಾರ್ಯರೀತಿಯನ್ನು ರೂಪಿಸಿದವರು ಗೋಪಾಲಕೃಷ್ಣ ಗೋಖಲೆ. ಅಖಿಲ ಭಾರತ ಕಾಂಗ್ರೆಸ್ಸಿಗೆ ಗಾಂಧಿಯವರನ್ನು ಪರಿಚಯಿಸಿ ದಕ್ಷಿಣ ಆಫ್ರಿಕಾದಲ್ಲಿ ಅವರು ನಡೆಸಿದ್ದ ಪ್ರಯತ್ನಗಳಿಗೆ ಕಾಂಗ್ರೆಸ್ ವೇದಿಕೆಯಲ್ಲಿ ಗಮನ ಸೆಳೆದವರು ಗೋಖಲೆಯವರು. ಗಾಂಧಿ ಮತ್ತು ಗೋಖಲೆ ಅವರ ನಡುವೆ ಎಷ್ಟೋ ವಿಷಯಗಳಲ್ಲಿ ಭಿನ್ನಾಭಿಪ್ರಾಯಗಳು ಇರ್ತಾಯಿದ್ವು. ಉದಾಹರಣೆಗೆ, ಗಾಂಧಿಯವರಿಗೆ ಸಮ್ಮತಿ ಇಲ್ಲದ ಮುಸ್ಲಿಂ ಪ್ರತ್ಯೇಕ ಪ್ರಾತಿನಿಧ್ಯ ವ್ಯವಸ್ಥೆಯನ್ನು ಮಿಂಟೋ ಮಾರ್ಲೆ ರಿಫಾರ್ಮ್ಸ್ ಸಂಬಂಧದಲ್ಲಿ ಗೋಖಲೆಯವರು ಬೆಂಬಲಿಸಿದ್ದರು. ಇಂಥ ಭಿನ್ನತೆಗಳಿದ್ದರೂ ಗಾಂಧಿ ಮತ್ತು ಗೋಖಲೆ ಪರಸ್ಪರ ಅತ್ಯುಚ್ಚ ಗೌರವಾದರಗಳನ್ನು ತಳೆದಿದ್ದರು. ಅಂಥ ಮೌಲ್ಯಗಳು ನಾವು ಇವತ್ತಿಗೂ ಕೂಡ ನೆನೆಯಬೇಕಾಗಿದೆ. ಸಾರ್ವಜನಿಕ ಜೀವನ ಎಂಥದೇ ಸಂದರ್ಭದಲ್ಲಿ ನೀತಿಯ ನೆಲೆಗಟ್ಟಿನಲ್ಲಿಯೇ ನಡೆಯಬೇಕು ಅನ್ನೋದು ಗೋಖಲೆ ಅವರ ಧ್ಯೇಯ ಸೂತ್ರ ಆಗಿತ್ತು. ಡಿ.ವಿ.ಜಿ. ತಾವು ಸಂಕಲ್ಪಿಸಿದ ಸಂಸ್ಥೆಗೆ ಗೋಖಲೆಯವರ ಹೆಸರನ್ನಿಟ್ಟದ್ದು ಗೋಖಲೆಯವರು ಪ್ರತಿನಿಧಿಸಿದ ಉನ್ನತ ಚಾರಿತ್ರ್ಯ ಮತ್ತು ಈ ಮೌಲ್ಯಾನುಸಂಧಾನದ ಕಾರಣದಿಂದ. ಗೋಖಲೆಯವರ ಸರಳತೆ, ನಿಸ್ಪೃಹತೆ, ವಸ್ತುನಿಷ್ಠ ಚಿಂತನೆ, ಎಲ್ಲರೊಡನೆ ಸೌಹಾರ್ದ, ಈ ಗುಣಗಳು ಸದಾ ಸ್ಮರಣೀಯವಾಗಿ ಉಳಿಯುತ್ತವೆ. ಒಂದು ಸಣ್ಣ ಉದಾಹರಣೆ ಅಂದರೆ, ಗೋಖಲೆ ಫರ್ಗುಸನ್ ಕಾಲೇಜಿನ ಪ್ರಿನ್ಸಿಪಲ್ ಆಗಿದ್ದರು. ಅವರ ಶಿಷ್ಯ ಡಾಕ್ಟರ್ R.P. ಪರಾಂಜಪೆ ಇಂಗ್ಲೆಂಡಿನಲ್ಲಿ ಪ್ರೌಢ ವ್ಯಾಸಂಗ ನಡೆಸಿ ಸೀನಿಯರ್ ರ್ಯಾಂಗ್ಲರ್ ಪದವಿ ಪಡೆದ ಮೇಲೆ ಫರ್ಗುಸನ್ ಕಾಲೇಜಿನ ಪ್ರಿನ್ಸಿಪಲ್ ಸ್ಥಾನವನ್ನು ಪರಾಂಜಪೆ ಅವರಿಗೆ ವಹಿಸಿ ಗೋಖಲೆ ಅವರ ಕೈ ಕೆಳಗೆ ಸಾಮಾನ್ಯ ಬೋಧಕರಾಗಿ ಮುಂದುವರೆದರು. ಅಷ್ಟು ಮಟ್ಟಿನ ನಿರಹಂಕಾರ ಗೋಖಲೆಯವರದು. ಅಂಥ ಉನ್ನತ ವ್ಯಕ್ತಿತ್ವದ ದೇಶ ಸೇವಕರ ಜನ್ಮದಿನ ಸ್ಮರಣೆಗೋಸ್ಕರ ನಾವು ಇವತ್ತು ಸೇರಿದ್ದೇವೆ. ಈ ವರ್ಷದ ಗೋಖಲೆ ಜನ್ಮದಿನೋಪನ್ಯಾಸವನ್ನು ನೀಡೋದಕ್ಕೆ ಸನ್ಮಾನ್ಯ ನ್ಯಾಯಮೂರ್ತಿ ವಿಷ್ಣು ಗಜಾನನ ಸಭಾಹಿತ್ ಅವರು ಆಗಮಿಸಿದ್ದಾರೆ. ಮೂಲತಃ ಉತ್ತರ ಕನ್ನಡ ಜಿಲ್ಲೆಯ ಹೊನ್ನಾವರ ತಾಲೂಕಿನವರು. 1974ರಲ್ಲಿ ಹುಬ್ಬಳ್ಳಿಯಲ್ಲಿ ಕಾಮರ್ಸ್ ಪದವಿ ಪಡೆದರು. ಅನಂತರ ಧಾರವಾಡದ ಲಾ ಕಾಲೇಜನ್ನು ಸೇರಿದರು. ಮೊದಲ ವರ್ಷ ರಾಜ್ಯಕ್ಕೆ ಮೊದಲ ರ್ಯಾಂಕ್ ಪಡೆದರು. 1977ರಲ್ಲಿ LLB ಪದವಿಯನ್ನು ಮುಗಿಸಿದರು. 79ರಲ್ಲಿ ರಾಜ್ಯಕ್ಕೆ ಮೊದಲನೆಯವರಾಗಿ ಫಸ್ಟ್ ರ್ಯಾಂಕಿನೊಡನೆ ಸ್ನಾತಕೋತ್ತರ LLM ಪದವಿಯನ್ನು ಪಡೆದರು. ಅನೇಕ ರಾಷ್ಟ್ರಮಟ್ಟದ ವಕ್ತೃತ್ವ ಸ್ಪರ್ಧೆಗಳಲ್ಲಿ ಕರ್ನಾಟಕವನ್ನು ಪ್ರತಿನಿಧಿಸಿದ್ದರು. VR ಭಟ್ ಸ್ಮಾರಕ ಪ್ರಶಸ್ತಿ, ಸದಾಶಿವ ಒಡೆಯರ್ ಸುವರ್ಣ ಪದಕ, ಧಾರವಾಡ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಪ್ರೈಸ್ ಹೀಗೆ ಅನೇಕ ಪ್ರಶಸ್ತಿಗಳು ಇವರಿಗೆ ಸಂದಿದ್ದವು. 1979ರಲ್ಲಿ ಬೆಂಗಳೂರಿನಲ್ಲಿ ವಕೀಲ ವೃತ್ತಿಯನ್ನು ಆರಂಭಿಸಿದರು. 85ರಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಆಗಿ, 88ರಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಆ್ಯಂಡ್ ಸೆಷನ್ಸ್ ಜಡ್ಜ್ ಆಗಿ ನೇಮಕಗೊಂಡು ಬೆಳಗಾವಿ, ಬೆಂಗಳೂರು, ಚಿತ್ರದುರ್ಗ, ಮಂಗಳೂರುಗಳಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸಿದರು. 1995ರಲ್ಲಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ ಆಗಿ ನಿಯುಕ್ತರಾದರು. 2000ದಿಂದ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರಾಗಿ ಮನ್ನಣೆ ಗಳಿಸಿದ್ದಾರೆ. ಹೆಮ್ಮೆಯಿಂದ ನೆನೆಯಬೇಕಾದ ಸಂಗತಿ ಎಂದರೆ ಇವರ ತೀರ್ಥರೂಪರು ನ್ಯಾಯಾಧೀಶ ಪದವಿಯಲ್ಲಿದ್ದು ವಿಶಾಲವಾದ ಖ್ಯಾತಿಯನ್ನು ಪಡೆದಿದ್ದರು. ಇವತ್ತು ಗೋಖಲೆ ಜನ್ಮದಿನ ನಿಮಿತ್ತವಾಗಿ ಭಾರತೀಯ ಸಂವಿಧಾನ ಮತ್ತು ಪ್ರಜೆಗಳ ಹಕ್ಕು ಬಾಧ್ಯತೆಗಳನ್ನು ಕುರಿತು ಉಪನ್ಯಾಸ ನೀಡೋರಿದ್ದಾರೆ ನ್ಯಾಯಮೂರ್ತಿ V.G.Sabhahit ಅವರು. ತಮ್ಮ ಉಪನ್ಯಾಸವನ್ನು ಆರಂಭಿಸಬೇಕು ಅಂತ ಪ್ರಾರ್ಥನೆ ಮಾಡ್ತೇನೆ. ಕೂತ್ಕೊಂಡು ಬೇಕಾದ್ರೂ ಮಾತಾಡ್ಬೋದು.
Honorary Secretary of this prestigious Institute of Public Affairs, Dr. Ramaswamy, Honorable Justice K.S. Putswamy, former Judge, High Court of Karnataka, the Secretary, office bearers, and all the members of this noble institute, distinguished invitees, ladies and gentlemen. I am happy to be with you all this evening. It is my proud privilege and honor to associate myself with this function arranged on the birthday of Sri Gopal Krishna Gokhale. I have been asked to render Gokhale Day address and speak on the subject rights and duties of citizens under the Constitution. I commence my talk with a sense of trepidation in the august presence of enlightened audience like Dr. Ramaswamy, Justice Putswamy, senior citizens and members of this prestigious institute, which is one of the best institute, which is a non-governmental organization dedicated to Rashtra Dharma. I would be failing in my duty if I do not commence my talk with a word of reverence and homage to Gopal Krishna Gokhale, doyen of Indian independence struggle and role model for all others to emulate, as he combined in himself all the qualities of head and heart. The life sketch of Gopal Krishna Gokhale has been already narrated by the Honorary Secretary, and I think I am too small to give the description of the personality of Gopal Krishna Gokhale. I can only say that his personality cannot be better explained than in the words of Mahatma Gandhi, the father of our nation, who has stated in his autobiography, My Experiments with Truth, that Mahatma Gandhi calls Gokhale as his mentor and guide, and also recognized Gokhale as an admirable leader and a master politician, describing him as pure as crystal, as gentle as lamb, as brave as a lion, and chivalrous to a fault, and the most perfect man in the political field. On this day, the birthday of Gopal Krishna Gokhale, it is our fundamental duty to pay our reverence and homage to Gopal Krishna Gokhale. Gokhale Institute of Public Affairs has been doing exemplary work in educating the citizens and the residents of not only Bengaluru but other parts of the state about their rights and duties, about their political status, and is having one of the oldest and richest library which is open to the public. It deserves all appreciation, and I compliment the Honorary Secretary and all the office bearers and members of this esteemed institute for the exemplary service they are rendering to the society. The subject on which I am going to talk today is rights and duties of citizens under the Constitution. Before delving into the subject of rights and duties of citizens, it is necessary to recapitulate as to what is Constitution, what is preamble to the Constitution, who are the citizens of India, to make us effectively understand the rights and duties under the Constitution. Constitution is a fundamental document for the governance of our country. It lays down the basic structure of national policy built on the foundation of certain fundamental values. Constitution is the testament of our founding fathers to the succeeding generation. Our Constitution contains the vision of our founding fathers, and its aims and objectives is enumerated in the preamble to the Constitution, which is described as the foundation stone of the Constitution, and it contains the gist of the constitutional contents. The preamble to the Constitution of India is acclaimed as the most solemn and most magnificent expression of declaration that can be found in any constitution of the world, and is worth quoting. I quote, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation." In our Constituent Assembly, this, the 25th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution, unquote. The preamble to the Constitution of India, which is described as key to the Constitution, begins the words we the people of India, which has significance of its own, as it is clear from the contents of the Constitution that people of India are vested with sovereignty of the state, source from which the Constitution emanates and enables them to continue to exercise their sovereignty in full. Naturally, our Constitution is the most democratic Constitution in the world. Constitution is suprema lex in our country. It is beyond the pale of controversy. And all the organs of the state, the legislature, executive, and the judiciary, derive their authority, jurisdiction, and powers from the Constitution and owe allegiance to it. Our Janma Bhoomi, India, is one of the 6 oldest countries of the world, namely India, China, Egypt, Greece, Babylon, and Mesopotamia. And India is the only country where the tradition of its ancient culture and civilization can be seen in every field of life. One of the most ancient civilizations of the world, India, can take legitimate pride in having been a civilizational unity without break for a long period of more than 5,000 years. We are all part of this great civilization and culture. Our contributions in the field of art, sculpture, architecture, mathematics, science, medicine, and law are well known. Some of the oldest, deepest, and sublime philosophical thoughts and literature were born in India. The golden voices of ancient India have come to us down the ages in unbroken continuity through countless rishis and sages, some of them world famous and some of them nameless. India of the ages is not dead and is still alive and wants to contribute something more to herself and the human race. The chairman and the members of the Constituent Assembly, which authored the Constitution of India, have taken all care to see that the high values of wisdom of India of the ages is manifest in the provisions of the Constitution. India is not the only country in the world. We have several countries in this world and we cannot live aloof. And we have to carry on the development of the nation with the cooperation and coordination of all the other countries. And we cannot live like an aloof island and secure our national interest and security of the country. And therefore, India has subscribed and signed international treaties and declarations. And therefore, every care has been taken in the Constitution to include the covenants of the international declarations and treaties. The vision of the Constitution is to secure to all its citizens justice, liberty, and equality. All persons residing in India are not citizens. All persons who are domiciling in India are not citizens. Citizenship is a bond that arises on the birth and flows from the law which governs the life of an individual throughout his or her existence from cradle to the grave. Citizenship at the commencement of the Constitution, that is 26th day of January 1950, on domiciles in the territory of India and the deemed citizens is dealt with under Article 5 to 8 of the Constitution. And Article 9 of the Constitution prohibits dual citizenship and states that if a citizen of India has voluntarily given up his citizenship and has acquired the citizenship of any foreign state, he ceases to be a member and citizen of the Indian territory. Every person who is or deemed to be a citizen of India at the commencement of the Constitution shall, subject to the provisions of any law that may be enacted by the Parliament, regulated regarding the continuation of citizenship and other matters relating to citizenship. And in pursuance of the said power, Parliament has enacted Citizenship Act 1955, which has come into force on 30th December 1955 and deals with acquisition of citizenship after the commencement of the Constitution, renouncement, termination, and deprivation of citizenship under certain circumstances. The Act recognizes acquisition of citizenship under the following modes: citizenship by birth, by descent, by registration, by naturalization, and finally by incorporation of territory. Our Constitution is a long document which contains 395 articles arranged in 22 chapters with 12 schedules. It guarantees essential human values termed fundamental rights in Part 3 of the Constitution, comprising of Article 12 to 35. And the next part, Part 4 of the Constitution, enumerates the directive principles for the governance of the country, comprising of Articles 36 to 51, which are in the nature of duties cast upon the state for the governance of this country. Fundamental duties were included in Part 4 of the Constitution by including Article 51A with effect from 1377. Part 3 of our Constitution specifically deals with fundamental rights and has conferred the following rights under respective heads. In my anxiety to prepare a comprehensive speech, my effort has swelled this speech into a long document, and therefore I would not like to read the speech page by page, and I would only be referring to the important quotations and enumerations of the rights and duties in the Constitution in the written speech. The Articles 12 to 35, which confer fundamental rights, has been described in the speech, and similarly other articles which have been classified as right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. The fundamental rights bind the state as defined in Article 12, included in Part 3 of the Constitution, and is a limitation on the power of the state to enact laws. Article 13 deals with the laws which are inconsistent with or in derogation of fundamental rights. Article 13(1) deals with the pre-constitutional laws which are in force at the commencement of the Constitution on 26th day of January 1950, and states that any existing law, insofar as they are inconsistent with the provisions of Part 3, shall to that extent be void. Article 13(2) deals with the post-constitutional enactments and mandates that the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of the clause shall, to the extent be void and thereby imposes limitation on the enacting power of the state in derogation or abridgment of the fundamental rights enumerated in Part 3 of the Constitution. The word law and law in force have been explained in Article 13.3. The above provisions contained in the Constitution reiterates the primacy of fundamental rights over other laws, and the right to approach the Supreme Court for the enforcement of fundamental rights itself is made a fundamental right under Article 32 of the Constitution, and thereby the Supreme Court has been made the protector and guarantor of fundamental rights, and the Constitution imposes a constitutional duty on the Supreme Court to protect the fundamental rights conferred under Part 3 of the Constitution. The approach of the Supreme Court in discharging its constitutional function as a protector and guarantor of fundamental rights cannot be better stated than in the words of Honorable Justice H.S. Kapadia, as he then was, presently Honorable the Chief Justice of India in M. Nagaraj versus Union of India. His Lordship said, "It is a fallacy to regard fundamental rights as a gift from the state to its citizens. Individuals possess basic human rights independently of the Constitution by reason of the basic fact that they belong to the human race. These fundamental rights are very important as they possess intrinsic value. Part 3 of the Constitution does not confer fundamental rights, but it confirms their existence and gives them protection. I repeat, Part 3 of the Constitution does not confer fundamental rights on the citizens, it confirms their existence and gives them protection. Its purpose is to withdraw certain subjects from the area of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be operated by the courts. Every right has a content. Every fundamental value is put in Part 3 as a fundamental right, as it has intrinsic value." His Lordship observed, "A right becomes fundamental right because it has fundamental value. Fundamental right is a limitation on the power of the state for enacting laws." His Lordship further observed that in interpreting the Constitution, a purposive interpretation has to be undertaken, not to whittle down the exercise of fundamental rights, but to enjoy the rights guaranteed in the fullest measure to be exercised. His Lordship has referred to the technical approach adopted by the Supreme Court in Sakal papers and A.K. Gopalan's case, wherein while construing Article 21 of the Constitution of India, which provides that no person shall be deprived of his life and personal liberty except according to procedure established by law, the Supreme Court by a majority held that procedure established by law means any procedure established by law made by Parliament or the legislature of the state. According to His Lordship, the Supreme Court refused to infuse the procedure with the principles of natural justice. It concentrated solely upon the existence of enacted law. After 3 decades, in 1978, the said interpretation was overruled in the landmark judgment in Maneka Gandhi versus Union of India, wherein Honorable Supreme Court held that the procedure contemplated under Article 21 must answer the test of reasonableness. The court further held that the procedure should be in conformity with the principles of natural justice. The Lordship further observed that expression life in Article 21 does not connote mere physical or animal existence. The right to life includes right to live with human dignity. His Lordship has concluded the observation by pointing out that the content of a right is to be defined by the courts. The final word on the content of the right is to be given by the Supreme Court, and therefore constitutional adjudication plays a very important role in the exercise. The words state for the purpose of Article 12, on which a limitation has been imposed under Part 3 of the Constitution, has been defined to include the Government and Parliament of India, the Government and the legislature of each of the states, and all local or other authorities within the territory of India or under the control of the Government of India. The fundamental rights bind the state as defined in Article 12 of the Constitution, as they impose limitation on the power of the state to enact laws, and empowers the citizens to approach the Supreme Court under Article 32 of the Constitution, which is itself made a fundamental right. And Honorable Supreme Court has given purposive interpretation to the word state, and has held that where there is pervasive or predominant governmental control or significant involvement in the activities, such bodies, entities, or organizations fall within the definition of state. As a result of judicial interpretation, the state has been held to include statutory bodies like insurance corporation, nationalized banks, airline corporations, electricity boards, education institutions, and societies, whose composition and administration are predominantly controlled by the government. Consequently, the reach and extent of protection of fundamental rights has been widened, and greater protection has been afforded, especially in the area of employment against discriminatory practices. In view of the decision of the Supreme Court, following the purposive approach, certain fundamental rights which are not explicitly included in Part 3 of the Constitution have been held to include within themselves certain intrinsic human values, and Supreme Court has deduced and inferred certain human values which are fundamental rights that can be implied from the fundamental rights explicitly stated in Part 3 of the Constitution. And this has given rights to at least 10 of the fundamental rights which has not been enumerated in Part 3 of the Constitution due to the purposive interpretation of fundamental rights conferred under Part 3 of the Constitution. Supreme Court said that freedom of press, right to travel and return to one's country, prohibition of torture and cruel, inhuman, or degrading the treatment of punishment, right to legal aid, freedom of information, remedy for violation of Article 21, right to free elementary education up to the age of 14, right to privacy, right to have access to courts, right to a clean and healthy environment should also be construed as fundamental rights conferred under Part 3 of the Constitution, as they are deducible or implied from the explicit fundamental rights. And as a result of the purposive interpretation by the Supreme Court in interpreting the fundamental rights conferred under Part 3 of the Constitution, the fundamental rights conferred on the citizens is extended to include the deduced and implied fundamental rights, which is implicit in the explicit fundamental rights contained in Part 3 of the Constitution. However, we must remember that no fundamental right guaranteed under Part 3 is absolute. And these rights are always subject to reasonable restrictions in the interest of unity and integrity of the nation. It is described that fundamental rights represent the claims of the individuals, and restrictions thereon are the claims of the society. The fundamental rights conferred under the Constitution cannot be waived, as there cannot be estoppel against the Constitution, and fundamental rights cannot be lost for non-user. Ladies and gentlemen, every right, whether moral or legal, carries with it a corresponding duty. In India of ages, much importance was given to duty rather than rights, as their wisdom dictated that performance of duty bestowed on a citizen would automatically confer corresponding right on the person to whom their duty is owed. They said the first duty of a citizen is to respect the rights of others and the state, and the first right of a citizen is to perform the duty so that right and duty never collide and correspond and complement and supplant each other and enable comprehensive development of every citizen and thereby the country, of which citizen is a unit. Men of wisdom of India of ages believed that rule of law, described as dharma, is a primal X like our constitution, and notice citizen, including the king, was superior to dharma. They described their wisdom in the stanza, tadetat kshatriyasya kshatram yad dharmaha tasmat dharmat atiparam nasti ato abaliyan baliyan samasamsate dharmo yata raja evam. Law is the king of kings. Nothing is superior to law. The law, aided by the power of the king, enables the weak to prevail over the strong. The above words of wisdom have been incorporated in the Constitution by giving sovereignty to the people of India and supremacy to the Constitution, and making all the organs of the state subordinate to the Constitution, which is the source of their power. Similarly, there are many other instances of words of wisdom of India of ages which has been incorporated in the appropriate provisions of the Constitution. The words wisdom of India of ages, that society should be duty-based and rights will follow the duty, was in the minds of founding fathers of the Constitution, the President and members of the Constituent Assembly. It is not as if that we were not aware of the fundamental duties. They were conscious of the fundamental duties enshrined in the ancient India. And, however, there were good reasons for not incorporating fundamental duties while drafting the Constitution, having regard to the fact that at that time the President and members of the Constituent Assembly had inherited the rich heritage of India of ages regarding good governance of the country, and they were the embodiments of the words of wisdom of India of ages, and therefore they thought that it was not necessary at that stage to incorporate specifically fundamental duties in the Constitution. The said sense of India of ages is contained in the saying that the sense right always emanates from selfishness, whereas sense of duty always emanates from selflessness. And therefore, the ancient Indians gave importance to duties which emanates from selflessness over the rights which emanates from selflessness. And India was described as the country which had given importance to the duty of citizens. They described Atrapi Bharatam Shreshtam Jambudipe Yatohi Karma Bhushana Tato Anya Bhoga Bhushanaha. Among the various countries, Bharat, that is India, is regarded as a great country as it is based on duty in contradiction to other countries which are based on rights or enjoyment or materialist values. However, with the lapse of time, degradation of values, particularly values in public life, became evident, and the nation felt that the need to amend Constitution to specifically incorporate fundamental duties, which led to the Constitutional Amendment, 42nd Amendment Act 1976, which incorporated Article 15A, the only article in Part 4A, which enumerates the fundamental duties of the citizens. And I deem it my duty to quote the fundamental duties that are cast on the citizens as they contain the intrinsic value, the human values, without which man and woman cannot live as such. Article 51A states, it shall be the duty of every citizen of India, A, to abide by the Constitution and respect its ideals and institutions, the national flag and national anthem, to cherish and follow the noble ideals which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity, and integrity of India, to defend the country and render national service when called upon to do so, to promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional divergences and diversities, to renounce practices derogatory to the dignity of the women, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures, to develop the scientific temper, humanism, and the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity, so that nation constantly rises to the higher levels of endeavor and achievement. The duties imposed upon the citizens of India, as described in Article 51A, contain fundamental intrinsic values, and therefore they are described as fundamental duties, as rights conferred under Part 3 are described as fundamental rights. However, there is no specific article in the Constitution or any provision for the enforcement of fundamental duties, nor as is there any provision prohibiting the enforcement of fundamental duties, as in the case of directive principles, which is not enforceable. Hence, it cannot be said that fundamental duties cannot be enforced at all at appropriate cases. However, it is beyond the pale of doubt that fundamental duties can be relied upon to sustain the constitutional validity of any statute, and in deciding the validity of the act, fundamental duties can be taken as a guide and aid for interpretation. In the case of All India Institute of Medical Sciences Students Union, decided in 2001, Supreme Court had an occasion to interpret the duties imposed on the citizens of India in Part 4A of the Constitution and observed fundamental duties as defined in Article 51A are not made enforceable by writ of court, just as fundamental rights are. But it cannot be lost sight of the duties in Part 4A. Article 51A is prefixed with the same word, fundamental, which was prefixed by the founding fathers of the Constitution to the rights in Part 3 of the Constitution. Every citizen of India is fundamentally obligated to develop the scientific temper and humanism and follow the duties enumerated in Article 51A of the Constitution. And Supreme Court said, after all, what is state? State is all the citizens put together. That is, all the citizens together constitute the state. And duty imposed on every citizen of India is the collective duty of the state. And therefore, it cast a duty on the state also, and upheld the provision that had been challenged in the said case, providing for reservation in All India Institute of Medical Sciences, New Delhi. Similarly, the provisions contained in Article 51A, which imbibes the human values, have been resorted to and taken as aid of interpretation for upholding the constitutional validity of the acts. Similarly, in state of Punjab and others, Hon'ble Supreme Court has explained the kindling spirit of clauses E and J of Article 51A and has said that administrators of the government are also primarily the citizens, and therefore their vision should be national interest. And in the said case, the order of the government giving weightage to the training and penalty for violation was upheld by holding that the fundamental duties oblige the administrators of the government to be good administrators. However, though fundamental duties have been imposed upon the citizens with effect from 3/1/1977, the same has not been sensitized among the citizens, and it is necessary to sensitize the citizens of India and make them aware of fundamental duties imposed upon them, which are already inherited by them through traditional values, so that they would attain excellence and help the nation's development. Pursuant to the duties that are contained in Article 51A, in M.C. Mehta versus Union of India, Supreme Court has given directions to the central government as also the state government and education department to create awareness and sensitize the citizens about the duties imposed upon them under the Constitution. Similarly, our Constitution has enumerated the directive principles of state policy in Part 4 of the Constitution, which are in the nature of duty imposed upon the state, comprised in Articles 36 to 51 of the Constitution of India. Though in the Constitutional Assembly debates, it was stated that the rights which are not enforceable have been put in Part 4 of the Constitution, it cannot be denied that the directive principles of state policy is meant for the governance of the country and is a duty that is cast upon the state to implement the directions contained in the said Part 4 of the Constitution. Fundamental rights are the negative and directive principles are the positive obligations on the state. The state is enjoined to adopt a middle path. The state has to maintain the balance, and the said balance is described as an essential feature of the Constitution. it is well settled that each of the article conferring fundamental rights or confirming fundamental rights are not to be read in isolation. Each of these rights are related to each other and are interconnected. And each right supports and strengthens the other. Similarly, directive principles are required to be implemented by the state for better enjoyment of the fundamental rights confirmed under the Constitution in Part 3. Fundamental duties which is imposed upon the citizens of India is also to be read along with fundamental rights conferred in Part 3 and Part 4, wherein directive principles of state policy have been enumerated. And therefore, Part 3, 4 and 4A of the Constitution form the same compendium and should be construed harmoniously to achieve the vision envisaged in the preamble to the Constitution. The Constitution, being a fundamental law, being the mother of other laws, is not a dead book, but a living document. Law, though stable, cannot be static. It is well settled that inn that shelters for the night is not the journey's end, and the law, like the traveler, must be ready for the morrow. The Supreme Court has been construing the provisions of the Constitution in tune with the changing times and modes of the society and development of the country to achieve the vision of founding fathers. The President and members of the Constituent Assembly had expressed certain apprehensions as to whether the Constitution would prove to be successful or otherwise, and whether vision of the founding fathers enumerated in the Constitution would become a reality. Dr. B.R. Ambedkar, architect in drafting the Constitution of India, expressed the following apprehension. I quote, "Will history repeat itself? Is this thought which fills me with anxiety. This anxiety is deepened by the realization of fact that in addition to our old enemies in the form of castes and creeds, we are going to have many political parties with diverse and opposing political creeds. Will the Indians place the country above the creed, or will they place the creed above the country? I do not know. But this much is certain, that if parties place the creed above the country, our independence will be put in jeopardy a second time and probably will be lost forever. The eventuality must be resolved and guarded against. We must be determined to defend our independence with the last drop of our blood." He further observed that his apprehension is as to whether India would be able to maintain the independence that is granted and as enshrined in the Constitution drafted by them. The people of India, who have imbibed the oldest and richest tradition and the values, have come up to the expectation of our founding fathers of the Constitution. The Constitution is working successfully. Elections are being held periodically in a most democratic manner, and electoral reforms have been introduced by taking advantage of development of science and technology in India. Elections are conducted periodically without any punctuation in most democratic and transparent manner, which has acclaimed the appreciation of all democratic countries in the world. The Supreme Court, which has been conferred with the task of protecting and guaranteeing the fundamental rights confirmed in the Constitution, has been discharging its constitutional duty and commands the reverence of the people of India for upholding and protecting the fundamental rights. The working of the Constitution has proved to be successful. A committee was appointed for reviewing the working of the Constitution of India under the chairmanship of Honorable Justice M.N. Venkatachalaya, former Chief Justice of India and the proud son of Karnataka. And in the report, volumes of success has been enumerated. And they have observed that Constitution is working successfully. However, they have made certain suggestions for amendment in Part 3 to include the rights which are deduced and implied from the explicit fundamental rights already confirmed by explicitly confirming in Part 3 of the Constitution, and have also suggested, in view of the decision of the Supreme Court, that the word state against whom the fundamental rights are binding and limits their right to enact should include all authorities carrying out public duties. However, so far as the fundamental duties are concerned, the committee felt that there is need for sensitizing the citizens by creating awareness among them and about the fundamental duties conferred upon them and their intrinsic value about the comprehensive development of a citizen and consequently the country. The Constitution of India, which is a fundamental document for governance of this ancient country, is being implemented successfully. However, there is scope for improvement and further improvement to realize the vision of founding fathers of the Constitution. Dr. B.R. Ambedkar has observed in his speech to the Constituent Assembly that independence is no doubt a matter of joy. But let us not forget that this independence has thrown us great responsibilities. By independence, we have lost the excuse of blaming the British for anything going wrong. If thereafter things go wrong, we'll have nobody to blame except ourselves. The President of the Constituent Assembly, Dr. Babu Rajendra Prasad, in his concluding address to the Constituent Assembly, observed as follows, I quote, "We have prepared a document, a democratic constitution, but the success of working of the democratic institutions requires in those who have to work them willingness and respect the viewpoints of others and capacity for compromise and accommodation. Many things cannot be written in a constitution or done by convention." He observed, whatever the constitution may or may not provide, the welfare of the country will depend upon the way in which the country is administered. That will depend upon the men who administer it. It is a trite saying that the country can have only the government it deserves. We must admit that defects are inherent in the situation in the country and the people at large. If the people who are elected are capable and men of character and integrity, they would be able to make the best even of a defective constitution. However, if they are lacking in these, the constitution cannot help the country. After all, constitution, like a machine, is a lifeless thing. It acquires life because of the men who control it and operate it. And India needs today nothing more than a set of honest men who will have the interest of the country before them. It requires men of strong character men of vision, men who will not sacrifice the interest of the country at large for the sake of smaller groups and areas, and who will rise over the prejudices which are born of these differences. And you observe, we can only hope that the country will throw up such men in abundance. However, Dr. Babu Rajendra Prasad expressed the hope that yes, I have no doubt that when country needs men of character, they will be coming up and masses will throw them up. And the recent example that can be cited, a popular example, is the leadership of the people of India, which was undertaken for fighting corruption. And the men of character and dependence had to lead the people of India to warn the government that government secures its source from the people of India who are sovereign, and they cannot deny the demands of the people of India. And Anna Hazare was the best example of that. And in times of need, many persons of such character and values would come up to save the Constitution. We, the people of India, shall endeavor to follow the guidelines given by the founding fathers of the Constitution and strive for the successful realization of our fundamental duties and enjoy our fundamental rights confirmed in Part 3 of the Constitution, and prove worthy of the confidence reposed in us by founding fathers of the Constitution. Let us follow the wisdom of words of D.V. Gundappa, who has played an instrumental role in the establishment of this institution and had been honorary secretary of this esteemed institution for more than 2 decades. And Dr. Ramaswamy is an eyewitness to that. He said, ತನ್ನ ಶಕ್ತಿಯನ್ನು ಅಳೆದು ತನ್ನ ಗುಣಗಳ ಬಗೆದು ಸನ್ನಿವೇಶದ ಸೂಕ್ಷ್ಮವ ಅರಿತು ಧೃತಿದೆಳೆದು ತನ್ನ ಕರ್ತವ್ಯ ಪರಿನಿಧಿಯ ಮೀರದೆ ಉಜ್ಜಯಿಸೆ ಪುಣ್ಯಶಾಲಿಯ ಪಾಡು ಮಂಕುತಿಮ್ಮ. ಕನ್ನಡದಲ್ಲಿ ಇದಕ್ಕೆ ಅರ್ಥ ಹೇಳಬೇಕಾಗಿಲ್ಲ. ಡಿ ವಿ ಗುಂಡಪ್ಪನವರ ಈ ಮಂಕುತಿಮ್ಮನ ಕಗ್ಗ ಸರಳ ಕನ್ನಡ ಭಾಷೆಯಲ್ಲಿದೆ. ಅದರ ಭಾಷಾಂತರ, ಬಿಫೋರ್ ಕಮೆನ್ಸಿಂಗ್ ಎನಿ ವರ್ಕ್, ಅಸೆಸ್ ಯುವರ್ ಓನ್ ಸ್ಟ್ರೆಂತ್, evaluate your quality, assess the effect of your work on others, beware of delicacy of circumstances, and work courageously without transgressing the limit of duties, and you shall be successful and be blessed. This is only a bird's eye view of the rights and duties of citizens under the Constitution. I have tried my best to comprehend the exhaustive provisions contained in the Constitution regarding the rights and duties of the citizens. Under the Constitution, I have already varied you much and would not like to vary you further. Without taking much of your further time, I express my gratitude to the organizers of this function for giving me an opportunity to visit this noble and esteemed Institute of Public Affairs and to deliver Gokhale Day address. And I also thank every one of you present here for giving me a patient hearing, and conclude with the epitemic note expressed by Rabindranath Tagore, which is also the vision of the founding fathers of the Constitution of India in Gitanjali, where the mind is without fear and the head is held high, where the knowledge is free, where the world has not been broken up to fragments by narrow domestic walls, where the words come out from the depth of truth, where the tireless striving stretches its arm towards perfection, where the clear stream of reasons has not lost its way into dreary desert of sand of death habit, where the mind is led forward by thee into ever-widening thought and action, into that heaven of freedom, my Father, let my country awake. Thank you all. Some type of domicile rights may be given to them, but Constitutional prohibits dual citizenship under Article 9 of the Constitution. Of course, that may be a good food for thought for the amendment of the Constitution to include dual citizenship in view of globalization and the developmental activities in the world. Yes?
ಸಂವಿಧಾನ ಕರ್ತರು ಮುಂದಿನ ಪೀಳಿಗೆ ಎಲ್ಲ ಹರಿಶ್ಚಂದ್ರರೇ ಬರ್ತಾರೆ ಅಂತ ಒಂದು ನಿರ್ಧಾರ ಮಾಡಿ ವಾಪಸ್ ಕರ್ಸ್ಕೊಳ್ಳೋದಕ್ಕೆ ನಮ್ಮ ಜನಪ್ರತಿನಿಧಿಗಳನ್ನ ಏನಾದರೂ ಒಂದು ಇದನ್ನ ಇಟ್ಟಿಲ್ಲ. ಅದು ಇವಾಗ ಎಷ್ಟು ಪ್ರಸ್ತುತ ಅನ್ನೋದನ್ನ
ನಮ್ಮ ಈ ಸಂವಿಧಾನವನ್ನು ರಚಿಸಿದವರು ಭಾರತೀಯ ಮೌಲ್ಯಗಳ ಆಧಾರ ಸ್ತಂಭ ಆಗಿದ್ದರು. ಅವರು ಮೂಲ ಕರ್ತವ್ಯಗಳನ್ನು ಸಹ ಈ ಸಂವಿಧಾನದಲ್ಲಿ ಅಳವಡಿಸೋದು ಅವಶ್ಯ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಅಂದರೆ ಅವ್ರ ಪ್ರಕಾರ ಎಲ್ಲ ಭಾರತೀಯರು ತಮ್ಮ ಸಂಸ್ಕೃತಿಯ ಹಿರಿಮೆಯನ್ನು ಅರಿತು ತಮ್ಮ ಕರ್ತವ್ಯಗಳನ್ನು ಪಾಲಿಸುತ್ತಾರೆ ಎಂಬ ನಂಬಿಕೆ ಅವರಿಗಿತ್ತು. ಆದರೆ ಇಂದಿನ ದಿನದಲ್ಲಿ ಪ್ರಜೆಗಳು ಅವರಿಗೆ ಪ್ರಜಾಪ್ರತಿನಿಧಿಗಳನ್ನು ವಾಪಸ್ ಕಳಿಸಬೇಕು ಅಂತ ಮನ್ನಣೆ ಅಥವಾ ಒಂದು ಆಶೆ ಇದ್ದರೆ ಅದನ್ನು ಸಂಬಂಧಪಟ್ಟ ಸರ್ಕಾರಕ್ಕೆ ತಿಳಿಸಿ ಅದನ್ನು ಮಂಡಿಸ್ಬೋದು ಅಂತ ನನ್ನ ಅನಿಸಿಕೆ. Dual citizenship is allowed in many countries.
Whenever I'm listening to your lecture, I felt it is something similar to when we listen to lectures on Ramayana, Mahabharata, etc. Because what is happening is everybody feels that constitution has completely failed. There is no rule of law. For example, if I give a small example, there was recently in one of the countries, they wanted a separate cycle lane. For that they were going on strike. You can see in Bengaluru, almost main roads are encroaching footpaths. Fine. And actually an ordinary person cannot express to anybody because executive is not having any authority on that. There are a lot of problems are there like this. There are hundreds of problems. When you mentioned Anna Hazare,
Yes.
we require maybe lakhs of Anna
Hazares
to really realize what Gokhale and Dr. Ambedkar has visualized about our
Yes, I appreciate your feelings, but kindly visualize as to what would have happened if there is no rule of law. Even for a minute, we cannot exercise our right, and government cannot exist, and there will be chaos. It is dharma, the rule of law, which binds the citizens to the state and citizens to the citizens. And the values is degrading from generation to generation, and every generation is a country for the purpose of the Constitution.
The rule of law is very much required and is working, but in case of garbage in Bengaluru, they have started collecting cess recently with the property tax. And if you go
No, that is a private right, not concerning the constitutional remedies.
this is also one of the
Yes,
duties of
steps have been taken.
governance.
In fact, I must state you that a public interest litigation has been filed already, which is pending before the Supreme Court, and the High Court also, and it may not be appropriate for me to express my opinion on a subject which is seized by the court.
ನಮ್ಮ ಮುಂದಿನ ಕಾರ್ಯಕ್ರಮದ ಬಗ್ಗೆ ಸೂಚನೆವಾದ ಪ್ರಶ್ನೆಗಳು ಬಂದವು. ಆದರೆ ಒಂದು ವಿಷಯ ನಾವು ನೆನಪಿಡಬೇಕು, ಈ ದೇಶದಲ್ಲಿ ಇವತ್ತು ಸ್ವಲ್ಪ ಮಟ್ಟಿಗಾದರೂ ಸ್ಥಿರತೆ ಇದೆ ಅಂದರೆ ಅದಕ್ಕೆ ಎರಡು ಕಾರಣ, ಒಂದು ಸಂವಿಧಾನ, ಇನ್ನೊಂದು ಸೇನೆ. ಇದನ್ನಂತೂ ಯಾರೂ ಅಲ್ಲಗಳೆಯೋ ಹಾಗೆ ಇಲ್ಲ. ಇಲ್ಲದೇ ಇದ್ದರೆ ಅರಾಜಕತೆಯೇ ಉಂಟಾಗ್ತಾ ಇತ್ತು. ದೋಷಗಳಿಲ್ಲ ಅಂತಲ್ಲ, ನ್ಯೂನತೆಗಳಿಲ್ಲ ಅಂತಲ್ಲ, ನ್ಯೂನತೆಗಳು ಬೇಕಾದಷ್ಟಿವೆ, ಕೊರತೆಗಳು ಬೇಕಾದಷ್ಟಿವೆ. ಆದರೂ ಈ ದೇಶಕ್ಕೆ, ಈ ಪ್ರಜಾಪ್ರಭುತ್ವಕ್ಕೆ ಒಂದಷ್ಟು ಸ್ಥಿರತೆಯನ್ನು ಕೊಟ್ಟಿರುವ ಅಂಶಗಳು ಅಂತ ಹೇಳಿದ್ರೆ ಒಂದು ಸಂವಿಧಾನ, ಇನ್ನೊಂದು ನಮ್ಮ ಸೇನೆ. ಈ ಅಂಶಗಳನ್ನು ನಾವು ಯಾವತ್ತೂ ಮರೆಯಬಾರದು. ಸಂವಿಧಾನ ಏತಕ್ಕೋಸ್ಕರ ಇದೆ, ಅದರ ಹಿಂದಿನ ದರ್ಶನ ಏನು, ಯಾವ ರಾಜ್ಯಾಂಗವನ್ನು, ಸಮಾಜವನ್ನು ಸಂವಿಧಾನಕರ್ತರು ಕಲ್ಪಿಸಿಕೊಂಡಿದ್ದರು ಅನ್ನೋದನ್ನೆಲ್ಲ ಈ ನಮ್ಮ ಸಂವಿಧಾನದ ಉದಾರ ಸ್ವರೂಪವನ್ನು ಉಪನ್ಯಾಸಕರು ಪ್ರಸ್ತಾವ ಮಾಡಿದ್ದಾರೆ. ರಾಜ್ಯಾಂಗದ ಸ್ವರೂಪ ಹೇಗೆ ಈ 5,000 ವರ್ಷಗಳ ಪರಂಪರೆಯ ಮುಂದುವರಿಕೆ ಅನ್ನೋದನ್ನು ವಿವರಿಸಿದ್ದಾರೆ. ಪ್ರಜೆ ಅಸ್ತಿತ್ವ ಉಂಟಾಗಿರೋದೇ ಸಂವಿಧಾನದಿಂದ. ಇಟ್ ಈಸ್ ನಾಟ್ ಆಟೋಮ್ಯಾಟಿಕ್. ಹಕ್ಕುಗಳು, ಬಾಧ್ಯತೆಗಳು ಪರಸ್ಪರಾವಲಂಬಿಗಳು, ಒಂದೇ ನಾಣ್ಯದ ಎರಡು ಮುಖಗಳು ಅಂತ ಹೇಳಬಹುದು. ಅದನ್ನು ನ್ಯಾಯಮೂರ್ತಿ ಸಭಾಹಿತ ಅವರು ಸ್ಫುಟವಾಗಿ ವಿವರಿಸಿದ್ದಾರೆ. ಹಾಗೆ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಅನೇಕ ವ್ಯಾಖ್ಯಾನಗಳಿಂದ ಈ ವಿಷಯಗಳಿಗೆ ಹೆಚ್ಚಿನ ನಿಹಿತತೆ ಬಂದಿದೆ ಅನ್ನೋದನ್ನು ಕೂಡ ಉದಾಹರಣೆಗಳ ಸಮೇತ ವಿವರಿಸಿದ್ದಾರೆ. ಶಾಸನ ಮಾಡೋದು ನ್ಯಾಯಾಂಗದ ಕೆಲಸವಲ್ಲ, ಇರುವ ಶಾಸನದ ಪಾಲನೆಯನ್ನು ಜಾರಿಗೊಳಿಸುವುದು ಪ್ರಮುಖವಾಗಿ ನ್ಯಾಯಾಂಗದ ಹೊಣೆ ಅನ್ನೋದು ಸ್ಪಷ್ಟವಾಗಿದೆ. ಆದರೂ ಇವತ್ತಿನ ಅಸ್ತವ್ಯಸ್ತ ಸನ್ನಿವೇಶದಲ್ಲಿ ಹೆಚ್ಚಿನ ವಿಶ್ವಸನೀಯತೆ ಇರುವ ನ್ಯಾಯಾಂಗದಿಂದ ಸಾರ್ವಜನಿಕರ ಅಪೇಕ್ಷೆ ಹೆಚ್ಚಿದೆ ಅನ್ನೋದು ಕೂಡ ನಿಜವೇ. ಈ ಸನ್ನಿವೇಶಕ್ಕೆ ನ್ಯಾಯಾಂಗ ಸ್ಪಂದಿಸಬೇಕಾಗಿದೆ. ಇನ್ನು ತೀರಾ ಕ್ಷುಲ್ಲಕವಾದ ಮತ್ತು ರೂಢ ವ್ಯವಸ್ಥೆಗಳ ಮೂಲಕ ಬಗೆಹರಿಸಬಹುದಾದಂಥ ಪ್ರಕರಣಗಳಿಂದ ನ್ಯಾಯಾಂಗಕ್ಕೆ ಅಧಿಕ ಹೊರೆ ಆಗದಂತೆ ಕ್ರಮಗಳನ್ನು ರೂಪಿಸಬೇಕಾಗಿದೆ. ಇದರ ಬಗ್ಗೆ ಕೂಡ ಗಮನ ಹರಿಸಬೇಕಾಗಿದೆ. ನ್ಯಾಯಮೂರ್ತಿ ಸಭಾಹಿತ ಅವರು ದಿ ನೀಡ್ ಫಾರ್ ಬ್ಯಾಲೆನ್ಸ್ ಆ ಅಂಶವನ್ನು ಪ್ರಸ್ತಾಪ ಮಾಡಿದ್ರು. ಇದೇ ಅಂಶವನ್ನು D.V.G. ಅವರು 1958 ಹಿಂದೆ ಬರೆದ ಒಂದು ಲೇಖನದಲ್ಲಿ ಸ್ಫುಟವಾಗಿ ಇದನ್ನು ಅವರು ಪ್ರಸ್ತಾಪ ಮಾಡಿದರು. ಒಂದು ವಾಕ್ಯ ಮಾತ್ರ ಓದ್ತೇನೆ. ಸೊಸೈಟಿ ಈಸ್ ಎ ಮೊಸೈಕ್, that it is variety that makes its elements need one another, so bringing them into unity. That the state's aim should be not uniformity, but unity based upon a rational adjustment of their positions. That true justice consists in the achievement of balance and harmony amidst variety. ಇದು D.V.G. ಅವರ ಮಾತು. ಹೆಚ್ಚಿನ ವ್ಯಾಖ್ಯಾನದ ಅಗತ್ಯ ಇಲ್ಲ. ನ್ಯಾಯಮೂರ್ತಿ ಸಭಾಹಿತ ಅವರು ತುಂಬ ಜಟಿಲವಾದ ವಿಷಯವನ್ನು ಆದಷ್ಟು ಸರಳವಾಗಿ ನಿರೂಪಣೆ ಮಾಡಿದ್ದಾರೆ. ಈ ಗೋಖಲೆ ಜನ್ಮದಿನ ಉಪನ್ಯಾಸಕ್ಕಾಗಿ ನ್ಯಾಯಮೂರ್ತಿ ಸಭಾಹಿತ ಅವರಿಗೆ ತಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ, ಗೋಖಲೆ ಸಂಸ್ಥೆಯ ಪರವಾಗಿ ವಂದನೆ ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೇನೆ. ಉಪನ್ಯಾಸದ ನಂತರ ಸಿಹಿ ವಿತರಣೆ ವ್ಯವಸ್ಥೆ ಇದೆ. ದಯವಿಟ್ಟು ಎಲ್ಲರೂ ಸಿಹಿಯನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗಬೇಕು ಅಂತ ಪ್ರಾರ್ಥನೆ ಮಾಡ್ತೇನೆ. ಈಗ